Hey everybody, I'm Lloyd Chatfield and this is the Business Law Boot Camp. Today we're going to talk about commercial leases, but first our standard disclaimer. This video is for informational purposes only, does not create an attorney-client relationship, and does not constitute legal advice in any jurisdiction. You'll know we're providing legal advice when we start invoicing you for it. So commercial leases. Most businesses lease their facilities, whether it's the headquarters, sales offices, manufacturing facilities, etc. It's often the first major contract a new company enters into. I've drafted and negotiated hundreds of leases over the years, representing both tenants and landlords, and have also been on both sides of disputes where things go wrong between a landlord and a tenant. Making sure you get the terms of your lease right can save you a lot of pain if things don't go as planned. In my experience, the major issues with commercial leases break down into four specific areas: rent, term, improvements, and maintenance. If you make sure you understand these issues and get them right in your lease, you've gone a long way toward avoiding any surprises down the road. First, rent. Rent in a commercial lease setting typically has two components, often called base rent and additional rent. The base rent is usually fairly simple, say $10,000 per month. The additional rent is usually a pro rata share of the expenses associated with the building. You may hear the term triple net lease, which essentially means the tenant pays all of the expenses associated with the premises, including taxes, insurance, and maintenance. The important thing is understanding the extent of your obligation for additional rent, what's included, and how it's calculated. The term of your lease is also a critical issue. Landlords usually like a long term, so they don't have to worry about vacancy, while tenants tend to like the flexibility of a shorter term. In my experience, 3 to 5 years is fairly typical. A common element of the term deals with renewals. Tenants should always negotiate for renewal options, which give them the right to renew the lease and retain the premises. Let's say your banana stand is making tons of money, but you're approaching the end of your 10-year lease. If the landlord sees just how much money is in the banana stand, and you don't have a renewal option, the landlord can refuse to renew, kick you out, and rent the space to his useless son-in-law to operate a banana stand. Landlords are often willing to give renewal options, but to protect themselves, they usually require that rent be pegged to fair market value at the time of the renewal. Much less common than renewal options is a termination right, which allows a tenant to leave early, usually with a penalty and a lengthy notice requirement. Landlords hate termination rights, but as a tenant, they're nice to have if you can negotiate them into your lease. The most important thing for tenants to remember about options and termination rights is this: you generally must follow the requirements exactly if you want to exercise these rights, especially with respect to the amount of notice required. If you have a renewal option or termination right with a 90-day notice requirement, your right to renew or terminate is gone forever if you miss that deadline, even by a day. It's a really good idea to make sure someone in your organization is tracking renewal dates so you don't miss a critical deadline. One final point on the lease term, and if you've already watched our segment on supply agreements, this will ring a bell. If you are a tenant, never ever agree to an automatic renewal. There's nothing worse than approaching the end of a lease with plans to relocate or get out of an undesirable location, only to realize that the lease automatically renewed and you are stuck there. No automatic renewals ever. Improvements. Improvements are changes to the premises to make them suit the tenant's business. Some landlords offer improvement allowances to entice tenants to their property, while others lease space as is. So make sure your lease is crystal clear as to who is paying for what. Also, leases are fairly universal in providing that any and all tenant improvements must be approved by the landlord. If you're a tenant and there are improvements you intend to make sure the lease grants you the right to make those improvements, or at a minimum that the landlord's consent cannot be unreasonably withheld. The final major issue with commercial leases deals with maintenance and repairs. The default provision is that the landlord is responsible for structural issues, basically the walls, roof, foundation, and common areas, and the tenant is responsible for everything else. But the parties can split this responsibility however they want. When I'm representing tenants, especially with an older building, we are very careful to put some cap or other limits on the tenant's maintenance and repair responsibility. As a tenant with a 5-year lease, finding out in the middle of year 4 that you have to replace the entire HVAC system can be a very expensive surprise. So make sure you understand your maintenance obligations up front. Commercial leases aren't sexy, and usually they aren't even strategic, but they are important, and getting them wrong can prove very costly. So that's commercial leases. As always, thanks for watching the Business Law Bootcamp. We'll see you next time.